My name is Elizabeth Grumet, and I am so excited to be part of CARE Law Group as of counsel. CARE Law Group shares my value system. So workers who are non-citizens have the exact same rights in California as citizens. Fair Employment and Housing Act is the law that protects workers. It's the state law, and it protects workers from to be free from discrimination based on race, ethnicity, age, religion.
Hello everyone, my name is Mehran Fardis. This is the CARE Law Group session today with Liz Grumet, an attorney in employment discrimination cases. I've known Liz for over 10 years and I know she's doing a fantastic job in the area of employment discrimination. Without further ado, I'm going to ask Liz, what made you become an employment discrimination attorney?
Well, my inspiration for a lot of things in my life has been my brother, Paul. He has Down syndrome.
Great.
And you've met Paul.
Yeah.
He's an amazing person. And when I went to law school, I knew I wanted to do civil rights. And I ended up doing that for about 8 years, 7 or 8 years. And I started my employment rights firm 3 years ago. And so I've been specializing in employment discrimination cases, wage and hour discrimination cases, so overtime, meal and rest break violations for 3 years. And I worked at an employment rights firm before that where we practiced those same areas of law. So mostly my inspiration has been my brother, but generally I have a huge passion for civil rights.
So to clarify again, if you're an employee, you're in a protected category, you got fired or you didn't get a certain type of treatment you deserved, and it was big because of discrimination and no other reason, this is when Liz comes in. This is the type of help she can provide. And so I'm going to ask her, what are the areas that are considered protected categories in California as discrimination?
California has really broad protections. So the Fair Employment and Housing Act is the law that protects workers. It's the state law, and it protects workers from to be free from discrimination based on their race, ethnicity, age, religion, disability, veteran status. I think I'm probably forgetting several, but it's a very large group. Religion.
I mean, earlier you mentioned something about pregnancy,
gender discrimination, sexual orientation, and gender identity. Those are all.
For example, let's say someone is in a protected category, it's a pregnant woman. Are women considered a protected category? Being a woman, is that a protected category?
Yes, I mean, gender discrimination, or gender is a protected class if you can show that you were discriminated on the basis of your gender.
Okay.
Yes, and especially pregnant women. I see a lot of cases where women have been discriminated against, retaliated against because they become pregnant, they might need some time off for medical appointments, and then they're suddenly fired before their pregnancy leave, or they're out on a protected pregnancy leave and they are fired, which is illegal.
So a lot of people, I think, would be hesitant to come to a discrimination attorney, employment discrimination attorney, because you would probably think it's a hard thing to prove. It's very hard to show that this employer really discriminated against me, even though you know that was the reason for whatever happened to you. What is your recommendation to this type of scenarios to people that have been discriminated against but are hesitant to come to an attorney?
That is the case most of the time. Most employees, they know that something happened that was wrong, they feel there was discrimination, and they don't know how to prove it. And so that's where I tell them, I'm the person who can help you determine that, because a worker is not in a position to have all the evidence to help prove their case, but there are various things that a court will look at to see, was this discrimination or not? Was this worker being treated differently than other workers of a different race or of a different religion, or being held to different standards, being written up unfairly and retaliated against? So the workers I see are a lot of times very hesitant. They don't know if they have enough evidence, and there's a lot of ways to prove discrimination. You don't need that smoking gun evidence.
So can you just quickly outline the process? Someone thinks they have a case. They come to you. What's the fee structure? What's the first thing you ask them? What are the steps that you follow through? Is this complicated? Is it simple? What's the process?
With me, it's not complicated at all. So workers can call me and we can set up a free consultation, either
Great.
in person. I've been doing most appointments during the pandemic via Zoom or on the phone.
Nice.
But it's very easy to assess what's happening on the phone, on a Zoom, chat, and then have documents emailed to me from the worker. And I provide, a lot more than most attorneys. Some attorneys in San Diego don't provide any free consultations, and sometimes I go for an hour and a half talking to a worker, and I don't charge for that time. And then, I do feel there's enough evidence or enough facts that lead me to believe there was something illegal happening and there was a wrongful termination, then we can sign up the case. And so, especially right now with everything happening with the pandemic, I've been very flexible, and I've entered into more straight contingency agreements.
Mm-hmm.
So that means I don't get any money up front, but I get a percentage at the end. Pre-pandemic, I had another arrangement also where I would take a very small flat fee and then get a percentage only if we win. So there really is no risk for the worker. It's the risk is on me, and I only take cases that I believe in and I believe will be successful. So.
And what is a desirable outcome for a client? Money, reinstatement of employment? What is it that usually they ask for?
That's a really good question. I usually put that question back onto a worker because I want to know from the beginning, what is your goal in this case?
Right.
Do you want to see, if a worker just wants to see changes in the workplace, those will probably happen by proxy as a result of their getting a settlement in their case. Some workers want a certain amount of money. That can be difficult because every case is worth a different amount. I have a lot of workers say, how much is my case worth? That depends on so many factors. It depends on when you were terminated and when you come to me, because you can be given back pay from when you were wrongfully terminated to when your settlement happens. Emotional distress damages are available, and those vary depending on how bad the discrimination was. If you have, let's say, a woman or a man or an individual who is a member of the LGBTQIA class being discriminated against based on their sexual orientation and assaulted, like a physical assault, those can get much higher damages in terms of emotional distress and also pregnancy discrimination cases.
So let's say someone has been discriminated against. They come to you, you have a conversation with them. Is there a fear of this person not being able to find a job afterwards because the past employer will find a way to taint the records or contact a new employer? Is this something of concern?
That is a very good question. Every worker who comes in has that concern, especially if we end up getting a settlement out of their case. They worry, am I going to be blackballed in the industry and I'm not going to be able to get work?
Yes.
And so any settlement agreement, any attorney who's worth his or her weight is going to make sure there's a clause in the settlement agreement that prohibits disparagement. So it's usually a two-way. The worker can't disparage the employer, and the employer can't disparage the worker. And then also, so that the worker has protection moving forward and using that job as a reference, we include a clause that makes it so that the employee can put that job down as a reference, and the employer who the worker has gotten that settlement from, when they are called about to get a reference for that worker, all they can give is the dates of employment and the last position that worker held. It's literally in the settlement agreement.
Is that something that's held negatively against an employee? Let's say you find a new job and they call your past employer, and your employer just gives facts instead of any opinion. Is that considered something not good, or is it something neutral? Should people be worried about it?
That's a very good question, because a lot of workers ask that as well. Isn't that going to be suspicious if a future employer calls and gets a reference and it's just this basic information? But nowadays, employers, especially large companies, are so afraid of litigation and being hit with defamation lawsuits.
Right.
They do that anyways.
They don't want to go back.
And they might just have a policy that they're going to give a neutral reference even if there's no settlement. And so it doesn't really look suspicious because so many do it anyways. But the settlement agreement gives you that security that that is going to happen. And if it doesn't, you can go in and get punitive damages against the employer.
So Liz recommends that people that have been discriminated against come forward, talk to her. There's really no harm in that process. Being in San Diego, the busiest port in the country as far as people crossing the border to Mexico, this is a big immigrant community. There's a lot of immigrants in San Diego and in California. So my question is, if a person does not have legal status as far as immigration is concerned and they're employee of a company and they get discriminated against because they're in a protected class, but they're afraid to bring this forward because they don't want retaliation from the company contacting immigration authority. Have you encountered this type of cases, and what do you do? What do you recommend to this type of employees?
I have quite a bit, and that's a very good question. It's very relevant in San Diego, especially because we have a very large immigrant community. Some of my clients have been in a position where they're undocumented or they're in the process of becoming a citizen, and they are not given meal and rest breaks. They're not being given overtime. I've had workers come to me, they were working 7 days in a row, 12 hours a day, and getting only regular time, never getting overtime, or being discriminated against because they're an immigrant. And it is illegal in California for an employer to threaten to call the immigration services to have a worker deported, especially if you make a complaint about your rights in the workplace as an immigrant and then an employer threatens to have you deported. That is very illegal. I have never seen an employer do that because they usually know that's not okay. So workers who are non-citizens have the exact same rights in California as citizens. So an individual who's even undocumented with no legal status at all, there's a lot of workers in that position. They're waiting. They're trying to get their citizenship. That can take years, and they can be diligently working with an immigration attorney, and they're still in this limbo status.
Right.
Those workers have the exact same rights as citizens and residents. So
under California law.
Under California law, because the courts and public policy is such in California that so many migrant workers are the backbone of our economy that the law doesn't want to reward employers who take advantage, because there's just an understanding they're hiring undocumented workers a lot of the time. And so these same laws that protect citizens, so for example, if you are working in a strawberry field or in a restaurant and you're undocumented and you are working 12 hours a day, you need to be getting your overtime after 8 hours worked.
Right.
You need to be getting your 30-minute break within the first 5 hours of your shift, and every 5 hours thereafter. So the laws protect you just the same as everybody else, and a lot of workers don't know that. And the law also really frowns on employers who retaliate against undocumented immigrant workers. And so I have represented a lot of workers in that limbo status, and very successfully.
Yes.
So, yeah.
And of course, as you guys know, we do have an immigration arm in our firm representing immigrants in their plight to become residents and citizens, and if they're being discriminated at the workplace and they're in a protected category, Liz will be the person who can help them. So I do encourage people to come to us if they feel they're in a protected class, they've been discriminated against, and have a conversation with Liz. No harm done. They find out what's the status of the case, and after that they can proceed or not. So I appreciate your time, Liz. This was wonderful, very helpful. Hopefully you guys enjoyed it, and we're going to do this very soon again. Thank you.